Welcome to the 9th and final video of a YouTube series covering the 2022 edition of A Detective's Guide to Interrogation Law. As we noted in the other videos, I'm intentionally giving away all of the substantive content of that book. If you watch all 9 videos and internalize the concepts explained in those videos, you will have expert knowledge of interrogation law without spending anything but your time. I think that you will find, however, that the book, and particularly the many case examples found in the book, are a valuable supplement to your viewing of the videos. It is bargain priced and available for purchase on Amazon. But if you choose not to buy the book, the free YouTube videos stand on their own and provide real value to viewers. So on to today's lesson. This is video 9, which covers mental defenses. Criminal defendants will sometimes seek to avoid liability by arguing one or more of these things: that they are not competent to aid and assist in the defense, that at the time that they committed the offense they had a severe mental disease or defect that rendered them unable to appreciate the nature and quality of what they were doing, or that rendered them unable to appreciate that what they were doing was wrong. That's the standard insanity defense. Or they may argue intoxication, a mental disorder, or extreme emotional disturbance prevented them from forming the specific intent required for committing the crime. That's called a diminished capacity defense. Looking forward to a capital sentencing proceeding, they may want to present mental expert evidence or arguments that a finding of future dangerousness is not appropriate. Mental issues are self-evident in murder cases, especially if no other obvious defenses apply. If, for example, a drunk and jealous husband kills his wife and then remorsefully confesses on the scene after a waiver of Miranda rights, the only thing left for the defense to argue at trial is insanity or diminished capacity. This often gets invented after the fact with the help of an attorney, so the best chance to get reliable evidence is in the initial interview. It is highly recommended that you obtain, study, and carry with you your jurisdiction's pattern instructions covering insanity and diminished intent if you plan to conduct interrogations of murder suspects who may later raise these issues. After the formal police interrogation is completed, consider arranging a jailhouse psychiatric interview. A suspect's early account of the pertinent facts surrounding the crime will likely be more reliable than a later interview conducted after the suspect has been coached by a defense attorney. As we noted in video 4, the psychiatrist in these interviews is the prosecution's agent and must obtain a Miranda waiver if the suspect is in custody or has been formally charged. Note also that, as we discussed in video 7, that the suspect's arraignment cannot be delayed for this purpose. After charges are filed, state and federal courts have statutory authority to order compelled mental examinations in cases where defendants raise competency, insanity, or diminished intent issues. These examinations do not violate a defendant's right against self-incrimination, but the Sixth Amendment requires that the government give proper notice to defense counsel before conducting compelled examinations. There's no right to have the counsel present in the interview room, however. This completes the series of videos. I am honored by the thought that many of you who are watching this have watched all 9 videos. I hope you will agree that the experience has made you a better interrogator. If you have comments about the presentation or questions about some of the points that I have tried to make in these videos, I can be reached by email at contact@trialdex.com. In closing, allow me to make a final request that you consider buying the book, reviewing the book, and telling fellow officers about it. You can readily find it by searching Amazon or follow the link on the front page of trialdex.com. While you are there, check out the companion book, 360 Federal Crimes. Again, thanks so much for viewing this, and thank you for what you do.